had given you into who can make a will. All of that is what is called testamentary capacity. Then we also have what's called the intention of the testator. This intention of the testator was brought about in a case called Banks versus Goodfellow. It basically talks about a person should be good sound mind. A person should be, in simple terms, a person should be knowing what they are doing. This is what the case of Banks versus Goodfellow tried to bring out. It's a very old case, but these old cases brought out principles, and later these principles became sections and laws into which the Successions Act is right now. Another feature of a valid will is that it should be made out of free will. It should be made without coercion. It shouldn't be made out of force. It shouldn't be made out of guilt-tripping someone. Number 5 is a valid will should be able to appoint an executor. Who is an executor? In most cases, the executor might be either the legal heir or the customary heir, but the executor can even be a different kind of person. So the executor is basically someone who is going to govern the property by which the deceased has left. Remember, like I told you before, in a will, one of the things, the hallmarks of a will is that the words of the testator, the words of the deceased person who is the testator, should be well respected without altering any word. Another thing that makes a will valid is that it should be signed by the deceased person who is a testator, the person who makes a will. Another thing is that it should be attested to. Basically, it means that it should be represented in the words, in the wishes of the person who is the testator. There are two types of wills. We have privileged wills and unprivileged. All that we've been talking about are unprivileged wills. An unprivileged will meaning that the will was made in ordinary circumstances. It was made in ordinary way. Like a normal day without any crisis. I'm the age of 50 years, I just decide, you know what, let me make a will. Anytime I may die. I've grown, I've amassed property, I'm a billionaire, I'm a millionaire, so I want to leave my property to who I want to leave it to. However, a privileged will is something that is made in most cases in the line of fire, which is the line of war. Privileged wills are basically given to people who are giving their last dying wishes, especially in combat. Privileged wills are given maybe to soldiers. In most cases, they're given to people who are in war, people who are in battle. So these are privileged wills. And in most cases, privileged wills are given orally. Now, all that I mentioned in terms of the features of valid will are stipulated under Section 50 of the Successions Act, Cap 162, especially the part that it should be signed by the deceased, it should be attested to by the deceased, it should be able to appoint an executor, a legal heir should be appointed, you should have testamentary capacity. So those are all of the features of a valid will. What are the factors that make it invalid? Because we've all talked about what makes a valid will, but now let me tell you what makes a will invalid. A will, in simple terms, the things that make it invalid are fraud, undue influence, mistake, and coercion. Yeah, that's basically it. I'll see you next time. Adios.